Hey everybody, Todd Vandermeid back for another edition of Freedom Steel. So yesterday we did Rahimi the Good. So today we've got the bad, and we'll be right back at you as soon as the intro rolls. So yesterday went over and did the Good of Rahimi, and the video was running a bit long at 18 minutes, so I dropped one part. One other good thing that came out of the Rahimi decision was that they sat there and they dispatched this responsible person, responsible citizen language that was in Heller. They sat there and responsible, the way they used it is nothing more than dicta. It just was an adjective to describe people who weren't criminals. And the court just now, it's important because the government has tried to use it. It ended up in oral arguments. And a good thing is that they put that down. But anyways, on to the bad. So Todd Vandermeid, former NRA contract lobbyist, Illinois gun law guru, sometimes called the Gun Santa over on Reddit. And today we're going to be talking about Rahimi the Bad. And as I look through this, there are a few bad things from our perspective on the context. So naturally, you saw, if you've read Thomas's dissent, and that's going to be a video unto itself, Thomas was very upset at them kind of going around the how the test was to be applied, how they were to look at the Second Amendment going forward, and that the first decision they come out with, they kind of parsed part of it away. So, and that comes in a number of ways. So what did they do? They did not say that 1791 was absolutely the area. They haven't made a definitive ruling. They're leaning more towards 1791 and a little after the ratification of the Constitution. That's what they're doing. They have not settled on 1865 to 1868, which is when the 14th Amendment was ratified, with the argument that, oh, this is what they were thinking when they ratified the 14th, which meant all the amendments applied to all the states. So that's still out there. They haven't decided that. It would have been nice. Would have been nice if they would have settled on 1791. They didn't, but several of them are leaning that way. You look at the concurrences, they're leaning that way. And so they talk, and part of this, I think, it comes into a bit of a because in Heller, they sat there and they said that, DC's storage law, where you couldn't have an operable firearm in the home, was unconstitutional. And they just kind of left it at that. They didn't go in and do any more. But here, in the main opinion, the chief writes, at the founding, the bearing of arms was subject to regulations ranging from rules about firearm storage to restrictions on gun use by the drunken New Year's Eve revelers. So it begs the question, what else are they going to do on storage? How far are they going to let that kind of BS go? And with them, I think the biggest thing that they did was they opened up the analogous, or what analogies can be used. Here, they said that the surety laws and the going armed to induce panic laws were close enough fit that that 922G survived the facial challenge, meaning that there was no set of circumstances where 922G could be found constitutional because just everything. Well, that and 922G is a bit different than the handgun ban that DC and Chicago faced, that under no set of circumstances could a handgun ban that broad be constitutional. So, with that, but they also dealt with the storage laws in DC, and so now this part here and whatever analogies, because remember there are those gunpowder storage laws. Now most will argue that that is a function of a fire code because gunpowder is very flammable and the like, not as much. But we all know that they have been trying for the last 2 years to shoehorn in everything they can. When it comes to gun bans, they keep talking about Bowie knife bans. And sooner or later, the court is going to have to put down Bowie knife bans do not equate to a gun. If you want to argue about a gun ban, you have to have an analogous set of laws, not a single law, but a set of laws from multiple locations from sometime around 1791 that talked or dealt with gun bans. And that therein is going to be the trick. It's just how far are they going to let some of these analogous, they're talking about a principle in here. And the concept is that the surety laws stood for the principle that dangerous people could be disarmed. Now, I think that the Bowie knife analogy would be applicable to the butterfly knife suit going on in Hawaii. That would be analogous for the state to try to prove up a claim. I don't think it should prevail. However, I don't think Bowie knife bans are going to be good enough to get to a gun ban. I'm pretty certain that that's not going to last in the proceedings down south. So there's that. Dangerous or unusual came up in a couple of these. One of my followers picked up on that during the live broadcast. And as I went back and went through the opinion again, dangerous or unusual only comes in when they are citing other 1791 era laws. They actually quote the law, and some of those laws talked about dangerous or unusual. But when the court speaks here, they use dangerous and unusual. We know that they have been trying to shoehorn this in a number of cases. They have intentionally been trying to use dangerous or unusual, so it's not a conjunctive test, it's a single test. So that will continue to be an issue for a while, I would think. I think that the credible threat stuff. On one hand, okay, there's a definite. You're talking a term of art, credible threat. There's no real definition. But what that leads us to is, what is the standard of review? Is it probable cause? Is the standard of review the bare minimum? Is it, a reasonable suspicion, which is enough to just get you a pat down and be pulled over? Is it a preponderance of the evidence? Is it clear and convincing evidence? Is it beyond a reasonable doubt? I would think that going forward, Justice Thomas, if he thinks that it should be construed this tightly in his dissent, that I think Justice Thomas is going to be going after beyond a reasonable doubt, that there has to be, the scales have to be tipped in such a manner. And it's going to be real interesting to get that next case up there as I go through my stuff here. So credible threat, it's going to be an issue. And for the interim, we've already seen the anti-gunners in Illinois sit there and say that, oh, Karina's law, it's fine, it's fine. A couple of months before they go back in veto session after the election to see what this does. And I think that we're going to see a bunch of arguments about that. We'll see where everybody kind of flushes out here in the meantime. That's the credible threat, like I said, was used 12 times in the main opinion and 23 times in the concurrences and everything else. I haven't got through Thomas's dissent yet. That's 25 pages. But like I said, that is going to be its own probably video about how it is, and this credible threat, it's, to what level? I mean, part of the decision says taken together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Okay, is that a bar fight? And individuals had a couple of bar fights, but they talk about, yeah, it doesn't say it has to be an arm in this case. Is a brawler just simply enough? I think that it's going to have to get flushed out. And the problem with this, the bad is it's going to lead to a ton more litigation on the nuances of everything. That the state, whether it be Illinois, California, whoever, they're going to be arguing this up and down. And one of the things that I think is going to be the biggest part of this is that this phrase, this term of art that the chief used, uh, where he said, nonetheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber. You are going to hear that phrase, a law trapped in amber, repeated by the other side ad nauseum. It's going to be their new catchphrase. That's what they're going to use every time they try to make an analogy that a Bowie knife ban is good enough for a gun ban. I think our founding fathers and those in the post-ratification era knew the difference between a Bowie knife and a firearm. But I think, you know, the good news, if you read the continuation of that whole sentence, nonetheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber. As we explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than those regulations identical to ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. So there's the whole paragraph that contains everything in a nutshell. They're kind of hanging on to 1791, but not really. They're allowing other analogies. It is not as strict as Justice Thomas would like it to be. And so with all this, that trapped in amber is going to be dovetailed with the whole, open analogies kind of thing. And we're just going to have to push back, which means it's going to be a bunch more litigation, which means we're going to be talking about the number of pixies dancing on the head of a pin. And depending on what judges see it what way, I think you are still going to have judges in the fourth, ninth, second, seventh sitting there trying to shoehorn whatever they want in. I think this paragraph right here was directly aimed at Bianchi, the Seventh Circuit, the Ninth Circuit with Duncan and Miller, but we'll see if they get the hint. We'll see. So that's the bad as I see it coming out of Rahimi. We'll get to the ugly a little bit, which is going to be more about more litigation, but we'll get to that, and then I'm going to do some stuff on how it applies to Illinois and where I think we're going to make some ground. So, as always, please, thanks for watching. Like, copy, share, paste this around the social media groups or forums you're in. Hit that like button down below. Help us out with the algorithms and everything to keep boosting our subscribers and everything. We really appreciate your time. And as always, frag out.